Hi, good morning, everyone, and a very warm welcome to everyone participating in this webinar today. My name is Willemijn Keizer, and I am the Executive Director of the Netherland-America Foundation. And this webinar, Immigration in the Time of Corona, is one in a series of occasional talks and lectures that we hold on business, cultural, historical topics, and also immigration topics in these very strange times that we're living in. The NAF is celebrating its 100th anniversary this year, and our mission is to strengthen the bonds between the US and the Netherlands. To accomplish this, we fund educational exchanges for Dutch and American students and scholars. We sponsor cultural exchanges, and we foster business ties between the US and the Netherlands. To make this possible, we ask for your support. So please consider becoming a member or make a donation. If you'd like to learn more about the NAF or about our NAF Biz chapter, please go to thenaf.org. For this webinar, Immigration in the Time of Corona, we have participants today from all over the United States, from the East Coast, the West Coast. We have many of you joining us from Texas and many other states throughout the United States, and also many of you from the Netherlands. So welcome, everyone. If you have any questions today for our main speaker, Steve Maggi, please use the question and answer function. And it is my great pleasure to introduce Steve Maggi to you today. And Steve has been practicing immigration law for the past 20 years in New York and in Florida, with a principal focus on entrepreneurial and business visas. So welcome, Steve. And without further ado, I look forward to hearing everything that you can share with us about immigration in the time of Corona.
Thank you so much. Thank you to the NAF. I've been a member for about 8 years now, and I'm always proud to let people know what's happening. It's been a very tumultuous time. So I'm going to share my screen. And to give you a little background on me, I am not Dutch. I'm actually from Argentina. And I moved to the States when I was a young child. My mom was a US citizen, but because she left the US at the age of 18, she couldn't get me a passport when we moved back to the United States. And I had to go through a 9-year process to eventually become a US citizen. So I decided in my youth that I was going to help other immigrants going through these difficult times because I've understood it and I've gone through it. And my main focus is working with other entrepreneurs like myself to be able to come to the US. And I've been very fortunate to work with a lot of Dutch companies over the years through my relationships through the NAF, and very proud to be doing this today. So let's just jump in and let's see what's happening right now. There's a game that I played when I was a child. It's called Frogger. I don't know if some of you are familiar with it, but essentially what you do in Frogger is you try to get across this very difficult path. And you've got cars and trucks that are trying to squash you, and then you have to go over land, and then you have to go over water. And so this is kind of how it's been in the last year and a half for Dutch and other European nationals and other people who are trying to get from their home country to the US. So how do we do that legally? That's our challenge, right? And so what we want to do is to make sure that we're not stuck inside or outside, or it may be game over. And that means being in a position where there's no recourse, where there's no solution. So let's talk about what's been happening lately. As many of you know, there's something called executive orders, and there were over 400 modifications to the way that the law and immigration policies under the Trump administration were administered and applied because of executive action. And so President Biden is starting to undo that, but you were talking about a lot of work that needs to be undone. Something we're going to talk about today a lot is the direct entry ban, which is currently now, it's been expanded to 36 countries. That includes all the Schengen area countries, including the Netherlands. And so for those cases, if you want to come directly to the US, you will need to apply for what's called a national interest exception. And I'm going to talk about that in more detail. There was a bar on the issuance of L1, H1, and J1 visas under the Trump administration, but that has been lifted by President Biden. So it's important to understand that if you're applying for those, that will be a possibility, but the issue is that there's a long delay on getting appointments now at the US consulate in Amsterdam. So if you're applying for F1s or J1s, you have the best chance of actually getting an appointment right now. and getting your visa, and then you can use your NIE that I'll talk about in order to directly enter the US. One of the things we're going to talk about here is addressing the concerns of people who are in the United States now and how they can protect their status. And so the good news is USCIS, which governs all the petitions within the United States, has continued to function throughout COVID and has been accepting applications for change of status, extension of status, as well as green card processing. And so one of the take-home lessons I'm going to talk about today is making sure that you're maintaining your status. There's no COVID exceptions here for somebody who's in the US. The public charge rule is something I won't talk about in detail, but it's something that was instituted under Trump, which would have put a lot of people's potential green cards at risk due to a potential hypothetical risk that they might become a public charge. That has been eliminated by the Biden administration. So you can take a deep breath if you're applying for a green card. That is no longer part of the process. And then the national interest exception standards are always changing. And we're going to talk about that. As of today, they have now been loosened after being restricted for about 3 months. And so one of the things that I was asked to say, and I'll remind you several times today, is that the information that I'm giving you today is always subject to change, because this is where I'm talking about how the law is applied in terms of policy, and that's changing on a weekly or sometimes a daily basis. E2 is the petition that I work on the most. We've presented many of them over the years at the US Consulate in Amsterdam and elsewhere, and I wanted to read to you what it says, what the email said that I got from the consulate directly. So I emailed them about a case that I was about to present, and they said that all appointments are currently suspended and that we should still send our E2 visa applications. They'll be registered, but they won't be processed until they resume the appointment. So there's a queue here, and the take-home lesson is, if you have your petition close to being ready, don't wait. Get it to the US consulate, the e-visa unit, and they will put it in the queue. Now, it is kind of confusing to say that appointments are suspended and that they won't review until the appointments are opened up again. There were some E2 visas that were actually processed and approved and given national interest exceptions automatically before about 3 months ago, when the consulate decided that they were putting a pause on appointments for E2s. So get in the queue is the take-home lesson when it comes to E2s. Let's talk about easiest to hardest scenarios. What are the different scenarios that are in play here? The first one is that you're already in the United States. Second one is that you're outside the US, but you hold a work visa, and that's where you might need a national interest exception to enter the US. The other one is if you're outside the US, but you have active ESTA status, but not a visa. So there are NIEs that can be applied for in certain circumstances, not in all. And then the most complicated one is outside the US with an approved petition, but you're pending a consular appointment or you can't get an appointment. I guess the last one really is if you are outside the US with nothing in process, and I'll address that briefly, how to balance what's happening and the delays with not rushing too fast to get to the US. How about those people that are here? So the bottom line is, the most important thing is to maintain your status at all times. The determining document is not your visa, it's the I-94 that you get electronically, and you have to look this up. The website is here, and I know we're going to be sharing this presentation, so you can go, or you can even Google I-94 and check most recent entry, and that will show you the date that you're authorized until. And it's very important that you use that as what's controlling and not look at your visa. I'm going to give you an example from today. This morning, I got an email from a Swedish client. The I-94 is expired June 21st, 2021. They didn't look at the I-94. They looked at the visa, which had a stamp until 2024. But when it comes to L visas, sometimes you will get a 5-year visa, and then that visa is actually limited by what's called the petition end date. So below the visa date, and when that expires, in the right-hand corner of your visa stamp, it will say PED with a date. That's the controlling date. That's the end of your expiration of your approval notice that you got from USCIS, and that's what's reflected in the I-94. So make sure if you do one thing today and you're in the United States and you're not on a green card, but you're in some sort of temporary visa status, my homework for you is check your I-94. Do it right away, because you might find out. But what I have to do with the Swedish client is ask for what's called nunc pro tunc relief, which means based on human error, could they please forgive the fact that this person fell out of status and now do an extension of status within the US? And that's up to the discretion of an officer for immigration service. It's very risky. So make sure that if you're here, you look at your I-94, and if it's close to expiring, that you are doing an extension of status within the United States. If you have an adjustment of status petition pending, that does not mean that your status is going to be maintained throughout that process unless you're going through a family immigration case. So if you have a business-based case, let's say you have an L1 visa and you're applying for what's called an EB1 multinational manager or executive green card, you need to maintain and continue to extend what's called underlying status, which is your L status. Or you could actually fall out of status, not be able to work, even though you have a pending green card case. Do not leave the country without a valid visa, because we don't know when you'll be able to get an appointment at the US consulate in Amsterdam, or if you're in another country, in one of the embassies or consulates outside the US. You need to make sure that your visa is valid, or what you should do is extend your status in the US. At the same time, you can, based on an approved petition, try to get an appointment. But I have Dutch clients who have had their appointments postponed several times, one from June all the way until September, and now until the end of the year. So you want to make sure that you don't get stuck outside the US without a visa, and make sure that that appointment is happening. So don't travel until right before your appointment. Not maintaining legal status means that you can be barred. So essentially, if you fall out of status for more than 180 days, when you leave the US, you're barred for 3 years. And if you do that for more than 365 days and you leave the US, you are barred for 10 years. And the chances of you getting a visa, again, are almost zero. So it's very important, if you're in the United States, your only priority should be to maintain your status. This is what's called an unlawful presence bar, and you don't want to incur that. And lastly, as I said in the beginning of this, do not rely on COVID as an excuse for overstaying, because the USCIS is not going to listen to those arguments. You are required to know where you stand legally, and you can't use the excuse of ignorance to have them give you the relief that you need. What if you're an employer? A lot of you are employing either Dutch nationals or other nationals on visas. The bright line rule is that if there is no job, there's no status. And the way that that's established is by payroll. You need to make sure that you're keeping people on payroll. Most visas allow for a reduced amount of hours, and it depends, and you'd have to consult with me which visas these employees are on. But some of them allow you to reduce. If it's an H-1B, for example, you can do an amended petition to part-time down to 15 hours. But if you stop paying the employee or you terminate them, then they begin to accrue on that unlawful presence, and then they may not be able to come back after. For H-1Bs, there is a 60-day, what's called gap, for finding a new employer. So the way you extend that is, if you're trying to be nice to your employees that you decided to terminate, is to extend their payments or to spread them out so they have a little bit more time in status in order to find a new employer. So the keys, and once again, to maintaining status, that you make sure you use USCIS in order to process extensions. A labor certification, or what's called a perm, does not maintain your status either. That's a separate process through Department of State. You always have to maintain underlying status. If you're going to be let go, make sure that you know your window of time to change employer. Some of you, for example, might be on E2s, and maybe the employer is going to let you go. What that means is that if you're Dutch, for example, you can find another majority Dutch-owned company in the US that could potentially sponsor you and do what's called a change of employer extension of status inside the US. Okay, so now you're outside looking in. We're shifting to the people that are not in the US, but that are overseas. The reason I show this this drawing here, this comic, is because people have joked, some seriously and some not so, that it seems easier to enter the US now illegally than it does legally. There is a wall now of immigration laws, and especially the policies that are used to implement those, that have made it very difficult for people to enter, especially with all the presidential proclamations, which create these direct entry bars that we've got now. So let's talk about these travel restrictions. What has stayed the same? Only one thing has really stayed the same, and that's a select group of people who can still enter the US directly from anywhere in the world. And that is permanent residents, citizens, the spouses and children of those people, and then crew members and diplomats. And so all this alphabet soup here essentially is crew members and diplomats. Those people can still travel directly to the United States. Everything else has changed over time. And this is where the logistics part of this comes in. How can Dutch or other European nationals outside the US enter the US now? So the real question that comes up first is, do you need to travel directly or not? There is a proclamation in place, which I mentioned before, that means that you cannot travel directly to the US if you're residing in any of those 36 countries that are covered in this proclamation. That includes Holland. And that also, there's something important to clarify. There's a 14-day period that applies here, which means if you go to any non-restricted country or several non-restricted countries, you need to have spent 14 days outside of Holland or outside of your restricted country before you enter the US. I had a client that said they knew somebody who went to Mexico, and 3 days later they entered the US and were allowed in. That's not what the proclamation says. So they were lucky that somebody misapplied the law to the facts, but I would not try that because that's not what the law says. Triangulation through third countries is sometimes simpler and less risky than getting a national interest exception approved. And so we're going to talk about the national interest exception, but it's really a question of balancing how fast you need to be in the US and really what your chances are of getting an approval of your NIE application. And that's something that I would recommend you use a professional to assess. So if triangulating is not an option, this is where the NIE, national interest exception, comes into play. So let's talk about just the basic process, the mechanics. The most important thing to understand here is that you already have to have active ESTA status or a visa, or you cannot apply. That's your base to apply for the exception. The exception is applied to your ESTA or to your visa, depending on what you've got. And so if you don't have ESTA yet, you need to make sure that you apply and get approved before you apply for the national interest exception. You also need to be if you're Dutch, you need to be in Holland when you apply for the NIE. You cannot be in the US and plan your NIE for the future because they will not accept it. You have to attest to the fact that you are in Holland when you apply. Nothing ventured, nothing gained is an expression that we use in English, and that means in this case, there's no penalty for being denied. So while you want to present a strong case, as strong as you can, it will not mean that your ESTA is revoked or that your visa is canceled because you're denied for the national interest exception. It means you just didn't meet one of the exceptions. Response times are slow. You need to expect a few weeks for a decision. Really depends on the embassy or consulate. I have Italian cases that when you apply, they say 60 days, which of course means if you have an urgent need, it's not going to be possible to meet it, and you might want to consider triangulating through a third country. So a lot of it is based on timing. If you're in a rush to get to the US, it might not be your best option. And if it's for tourism only, then I would suggest triangulating because it probably won't meet the NIE standards that we're going to talk about. If you're a company that needs to request multiple employees, you want to do it in separate applications because it's really the application is filed by the individual and not by the company itself. And you can have attorneys represent you on a consular level by signing what's called a G28 form. Who has the best chance of getting an NIE? Well, if you don't have a visa, there are certain categories that automatically qualify, and those are students and what are called vocational visa holders. So if you're going to study at how to be a beautician, for example, you would get an M visa. You're not required to get a national interest exception. So those two categories are at the top. The next, you've got J1 trainees, as well as journalists and crew members. Those people can get expedited appointments because they really do have an urgent need to be somewhere at a certain time. And the NIEs are, in my experience so far, have always been approved for those categories. The caveat here is that the start date for training or study must be after the interview date. So you want to use those expedited appointments, and if you need to change that I-20, if you're a student, or if you are in J1, it's called a DS 2019, you want to get that start date to be after the interview date. They can't apply it retroactively. So that's a small detail. It's very important in terms of timing. Let's talk about the qualifying criteria. So this one, business or significant economic investment, was the one that we've been using since end of summer last year until March. And then the Department of State got rid of it. Now it's back. It's been back for just a short amount of time, which is a big relief because we have more flexibility in terms of justifying why somebody needs to be there. And here's the magic language that you need to use in your letter. So if it's a US company and you have a visa to work for that company, then that company letter wants to say that you're providing support, vital support, executive direction, and talk about the significant activity, economic activity that is involved. And that always has to do with job creation. So this is what we call carrot and stick. You say, I need this employee that I have on an E2 or an L1 or an O1 or whatever the visa is to come to the US, because when that person is here, they can implement the business plan, they can generate growth, and they are in charge of hiring more people or managing more employees. It's all about job creation, especially now where we have the highest unemployment rate in the US that we've had in a long time. So the letter should also address these questions, which are the specific activities, how they provide vital support, why those activities require physical presence in the US, and as a part of that, why they couldn't be replaced by video conferencing or teleworking, right? And we're going to see another standard that's also applied for NIE, which is complicated as well, but they have essentially the same questions that are being asked. Why does the person need to be physically in the US? And usually that's where you bring in letters from US companies supporting the petition, saying, for example, Willem needs to come to the US for XYZ meetings on these specific days where we're going to address these specific issues. We're going to advance our collaboration, which will lead to more jobs and more revenue, etc. That's the most important element that you can use here. Is not just the letter from the US company, but that is sponsoring the individual, but other US companies that are collaborating or meeting with the individual. A lot of these cases also involve employees of foreign companies, let's say a Dutch company that does agricultural projects, and they have a contract with the US company that wants those specific individuals to come and help finish that project. We've done a lot of NIEs in those cases. And that's where the letter from the US company that has the agreement with the foreign company is absolutely necessary. And all this needs to be put into one PDF to make a strong presentation. So this criteria is now back on the books, which makes it a lot more accessible for anyone who doesn't have it yet. The new standard, which was called critical infrastructure, replaced the economic necessity standard, and now they both are back on the books. And so if you have any sort of project or business dealings with these specific sectors, then you have a very strong case. What you have to argue is that you are working on a project that is part of this critical infrastructure, and you want to cite this specific list here of different sectors that are part of this, the CISA.gov list. If you're lucky enough to, you can argue both standards if they apply to create an even stronger case. So as I mentioned before with the business necessity, these are some of the same questions that you have to answer if you're only presenting a critical infrastructure argument. But the most important thing is physical presence. Why does that person need to be there physically? That's where the letter from the US companies that you're also working with is extremely useful. So I have some good news. There's not been a lot of good news, but the national interest exception now, as of June 29th, has been extended for 1 year for all people who have a previous approval, so from that date. If you've been granted multiple NIEs, then you could use the most recent one. And that's 1 year from the approval date in an email that you've gotten from the US consulate in the Netherlands or whatever consulate or embassy you applied. So for example, if you were approved on October 20th, 2020, you can use that NIE approval until October 1st of 2021 to enter and remain as many times as you need to according to your visa or your ESTA. So if you have a 5-year visa or a 3-year visa, let's say you have a 3-year E2 visa, you enter before October 1st, 2021, you can use that until the end of your authorized stay, okay? And that goes back to what I talked about, the I-94. So make sure, with ESTA, it's only going to be 90 days, but you can re-enter as long as you can continue to prove that the purpose of your entry is the same. So you want to keep that same packet, maybe update the letter from the US employer or the US company that's part of this that needs you there physically. What if you have no visa? So consular processing, this is Amsterdam, but this applies in a lot of, it's very important to stress here that not only are things changing all the time, but that every US embassy and consulate has different rules and regulations, procedures. Some are processing E2s right now, for example, some are not accepting them, some are putting them in the queue, and it changes depending on the embassy or consulate. This is important because Amsterdam is extremely backlogged. So you can expect delays of 4 to 6 months or more if you're applying for visas with O, P, H1B, or L1 categories. The longer you wait, the longer the line gets. Now, I've never encouraged what's called forum shopping before, but in this specific case, I have examples of cases, Dutch clients as well as others, who have gotten appointments at multiple embassies and consulates and actually gotten their appointments and gotten their visas approved before the one in Amsterdam was able to process them. And so I have a Dutch singer, for example, she was approved in March. She got an appointment in June, it was canceled. Then it was canceled for September. So she got an appointment in Bern, Switzerland, where they had waived the residence requirement, which is generally required for people applying. And now she's in the US. She was able to get an NIE through a letter from the production company that was sponsoring her. So I would say it doesn't hurt to have multiple appointments in several posts. And that's always changing in terms of how flexible each one is, because once the word gets out, then they get inundated with cases and then they pull back. But this is one case where forum shopping might be important if you already have an approved case. One thing I'll talk about is if you're planning for the future, you want to make sure that you push these dates back, the start dates for your petitions further back as much as you can, because you don't know when you're going to get an appointment. So I'll talk about that a little bit more. The longest path here is the one that we've always had. For example, if I go to Holland and I do a presentation and then I talk to entrepreneurs who are interested in potentially setting up US operations, it's the same scenario, but we have to take into consideration the COVID factors. So one thing is universally true is that you can take advantage of your NIE to enter the US to set up your business. And so once the US company is incorporated and you funded it, then we can make an argument to get a national interest exception for you to enter the US directly and start building out your business. You want to do the evaluation, of course, of E2 versus L1 if you're an entrepreneur. The E2 requires that the US company be at least 50% Dutch owned. If you're Dutch, the nationalities have to match. And so that's an important consideration. And then you need to make sure you take the most basic steps to potentially apply, which are setting up the business, the bank account, funding it, having a complete business plan, and having what's called sufficient physical premises for you and for the people who will be hired in the first year. So that's still true, and that's important to keep in mind. What I would say here is, most importantly, let's say you want to apply for an L1, maybe put a start date of January 1st, because if it's what's called a new office L1, you'll only get 1 year, and the end date that's stipulated on your petition is fixed. So if you take 6 months to get an interview, then you're going to lose 6 months off the back end of your visa. And so you want to take COVID into consideration and the backlog, especially at the US consulate in Holland, keep that in mind when you're planning and project out. because otherwise you're going to lose precious time to build out your business when you get to the US. The same thing goes for sponsorship for any professionals, O1s, H1Bs. You want to make sure that you're getting the sponsorship first, of course, but then you want to push that start date out as much as you can, because those petitions are submitted to Immigration Service, and then you have to get an actual visa appointment to be able to enter the US with that sort of status. Forum shopping is not something I generally encourage, but I think in this case, there are examples of where that might be beneficial. And please do not come to the US under ESTA or a tourist visa and start working without proper visas. So this has always been true, and a lot of us have seen the complications. Your company can get blacklisted, the person can be excluded from the US permanently if there is a suspicion or proof that they were working without authorization. So for those people who are coming to set up their businesses, applying for L1s and E2s and waiting, make sure that you're doing only the things that you're allowed to do when you're in the US temporarily without the authorization to work. Let's just do a few take-home lessons here. There's still no end in sight for the lift on the entry bar and the clearing of backlogs. So the one-year extensions for the people who already have approvals for NIEs are very helpful. USCIS is still accepting and processing petitions, so utilize it by changing status, extending, continuing green card process. Do not leave the US without a plan. No improvising, because you might be stuck overseas for many, many months. And I unfortunately have clients who have just decided from one day to the next to leave, and it made things very complicated for them. COVID-19 is the continuing X factor here that justifies these delays and the changes in policy. So this is always changing, and you need to make sure that you're speaking with someone who understands what today, where the law stands. Expect backlogs on visa processing and plan accordingly. Get appointments now or shop elsewhere. As I mentioned, you can have 2 or 3 or 4 appointments in different embassies and consulates. Take the one that gives you the opportunity to get your visa first. And then use the national interest exception as a tool if possible, and stay on top of changes. So for anyone who doesn't have the NIE yet, don't wait until they get rid of the NIE and allow people to re-enter, because we have no idea what that means. To me, the extension of NIEs that are already approved for 1 year means that we're looking at a long time before anything is completely removed in terms of direct entry. And obviously you want to talk to an experienced immigration attorney if you have questions about what your path should be. Happy to take questions now. I'll stop sharing. My info is there, but I think that will be shared after. So does anybody have any questions?
Actually, Steve, I hope you can hear me.
I can.
Yep. This is Jacob. I'm chairing the NAF BIS committee. There are a number of questions, and I'll try to group them. And for everyone whose question I cannot address, Steve has offered to be available for a 15-minute, no commitment interview, and give you a little bit of consultation for everyone who's a NAF member. So please rush to become a NAF member if you're not one yet. I had a couple of easy questions. Yes, the presentations will be shared. I think that was addressed already, but let's make sure that everyone realizes it will be shared. However, everything that will be shared is only valid as of July 13, because things change every day. Let me start by the following, Steve, and I'll try to group the questions a little bit.
Okay.
People who are in the Netherlands, who are in the US now and go back to the Netherlands, you basically said, I discourage that. If you're in the US already, stay in the US, try to extend your status in the US, look at your I-94.
Right.
But if they do go back to the Netherlands regardless, you can only, can you confirm that? You can only apply for your NIE in the Netherlands, and you cannot yet apply for an NIE in the US.
Correct. So I was saying earlier, don't plan to leave thinking that you can wait and see if your NIE is approved before you leave the United States, because they strictly prohibit it. And I don't know exactly how they would know, but certainly when they look at your I-94 at some point, and it will show your travel history, when you actually left. And so, yes, you're required to be in Holland when you apply for the NIE, if you're Dutch or whatever country you're from in that country.
And then from my own experience working with my clients, that NIE processing time, not only the visa applications, but the NIE processing time has also gone up quite considerably in Amsterdam. Can you say more about that?
Yeah, I agree with you. When we did our first event, I remember they had just launched the NIEs and they were approving them in 3 or 4 days. And now I've seen 2 to 3 weeks in terms of processing. I think that's why they've extended the previously approved NIEs for 1 year, so they don't have to process a lot of them. So the number of cases is going to go down again, and I think it's going to be more efficient.
And would you then have to argue that you had to go back to the Netherlands for a special purpose and then want to go back? For instance, there's a question from an L2. They need to go to the Netherlands, and is there a real reason to go back to the US, except for the fact that they live here on an L2? The reason was to go back to the Netherlands, not the other way around.
I have always, when I present the cases on my own in my attorney letter, I've always justified why they left the US, and it's usually for some sort of emergency. That always holds more weight than saying I just wanted to see my family. Certain embassies require that both of the individuals, the dependent spouse and the principal L1 in this case, apply together, which means that this person might need to have their spouse in Holland when they apply for the NIE. If the spouse is still in the US, they may just need to triangulate through, because usually it's dependent on the principal visa holder. Okay,
so if the L1 had to go back to the Netherlands for business purposes, the L2 joins, then would the L2 automatically get that NIE as well?
Yes, yes. So they look at the merits of the case based on the business necessity or critical infrastructure, and then all the dependents are automatically approved along with the principal visa holder.
Okay. Then I have a couple of questions that I'm gonna try and combine. A Dutch-Australian dual citizen staying on an E3 would like to visit consulate in Amsterdam for a visa for a new E3 visa stamp. What can he do to prove I want to go get my visa in the Netherlands instead of Australia? I have all my direct family and bank accounts in the Netherlands.
Okay, so the problem with that is that there's no preferential treatment for E3s. I mentioned the categories like M, F, J, C, and D that get preferential treatment for expedited appointments. E3 is not one of those, certainly not in Holland, because it's an Australian visa. And so I would strongly recommend this person extend their E3 status if they're within 6 months of that having expired. And when that's approved, they can eventually use that to get an appointment, but I don't think they're going to be getting an appointment until at least the end of this year, because it's not a high priority. They can, if they show that they're residing in Holland and that's where their families, etc. They can probably get an E3 approved there and don't have to go back to Australia, but there's no guarantee of when they'll get an appointment right now, logistically. And so extending the E3 status is definitely the best idea if they're close to having that expire.
Okay. Some questions here on the traveling out to a country for 14 days. How do you actually show that you've been in that country for 14 days? And do they look at that?
But that's a good question. But the problem is I cited the example of a client who knew someone who came in through Mexico and was only in Mexico for 2 days. It depends on the officer that's from Customs and Border Protection that's looking at your paperwork. But most countries will stamp your entry and it'll be on your passport. So they need to show the stamps from that non-restricted country. Let's say they go to Turkey or UAE, they need to show the stamp where they entered and the stamp where they left, or the stamp where they directly entered the US. So they're going to be calculating and looking at their passport stamps to see when they entered those other countries.
Okay. So it is important to keep that in mind, and they know more about you. Also, I guess from social media, then some of you realize, because they definitely do look at social media.
I would just say, Jacob, that the government has a lot more information than I know or you know about individuals and where they're traveling. So I think that there's a way for them to find out where people have been and for how long, if they need to find it out.
Great, thank you. Then I had in general, say, get in the queue early. So would that mean that for people who may think that they need to apply for or go to the US under an NIE, that they, in the upcoming year, that they might as well apply now?
No, I wouldn't say that, because you have to show urgent need and business necessity. And that's really all about urgency. So when I talked about having US letters from companies to justify and essentially support these petitions, it's really important to have an itinerary, to have specific dates on those to communicate a sense of urgency. Otherwise, they're not going to get the NIE. NIE is really for people that need to travel, like we talked about before, in the spirit of NIE, which was for 30 days, which no longer applies now. If you have an approved one, you can use it for the whole year. But before, it was up for travel within 30 days. So that's the benchmark still, Jacob, is if they need to travel in the next 30 days, make it urgent. Put a date on it. So don't apply unless you have something specific that you can cite in terms of dates.
Okay. The question here, do I need an NIE if my children are US citizens and I want to go basically back to the US for that purpose?
So the answer is no. That's still a protected category. That's one of the categories that still allows you to travel directly to the US. If you're a direct relative of a US citizen, you can still travel to the United States.
So you don't need an NIE because you can then, how do you show that your children are US citizens? Copy passports or?
Yeah, birth certificates.
How does that work?
Birth certificates showing that you're the parent, and then the actual the US proof of US citizenship, which will be a passport, birth certificate, or a naturalization certificate.
Including residents, because they could be a US citizen while living outside the US.
Yes, as long as they're citizens, it doesn't matter if they're there or not. If you don't need to justify it by saying necessarily you're going to see them, but that would be the best, that would be the strongest argument that you could make, obviously, if you're entering the US.
Okay. Let me see. I think I answered a number of questions already. Here a question about the G4 visa.
Okay.
Do I need to write down the embassy in The Hague on the form of the consulate in Amsterdam? And when my employer sent the document, do I have to go to the consulate or the embassy? On a G4, I guess that's a UN related visa?
Yes, so that's all visa issuances are through the consulate in Amsterdam.
Okay. But I guess for G4s, there's no NIE requirement. So this is more about the G itself.
Correct.
Okay. If you have an EAD, AP card, and a future job contract, can you then enter the US without an NIE, or do you still need to apply for an NIE?
So an EAD does not grant you entry into the United States. And this is a really complicated question, but what you need is underlying status. So you might have an H-1B or an F-1 or something that allows you, or you're the spouse of someone that's a visa holder that allows you to have the EAD. So the answer is you can apply for an NIE, but it's not based on your EAD or your future contract. It's based on a visa. And if all you have is the EAD and that you don't have a visa, a valid visa to enter the US and work, or a valid status like a green card, then you're not going to be able to enter the US. You're going to need that visa or whatever document you need to show that you're authorized to enter the US. Then you can apply for the NIE.
Okay. Here there's a question that goes back to the presentation that the consulate gave in, I believe it was March. Mm-hmm. In the last webinar, it was clarified that there would be an effect on your future ESTA applications if your E2 application is now denied because of not qualifying for the NIE. Is that still in place?
I think as a general rule, once you've had any visa denied, your chances of getting an ESTA approved after that are almost zero, because there's no interaction with an officer to explain the situation. And so you have to put that you had a visa petition denied on your application, and that automatically triggers a denial under ESTA.
Okay.
So I guess going the second part of that would be if you have an approved E2, our experience has been with the consulate, then if you have an approved E2, they've always granted the NIE.
Automatically.
Yes.
Okay.
In fact, they were giving our clients a piece of paper at the interview saying you've also been approved for NIE. So I think that that's still the case.
Very good. My NIE was refused for an E2 visa, it says here. Is it possible? So apparently someone did get a refusal on the NIE with an E2. Is it possible to submit another one? I guess this is someone who was on an E2 already, not where it was not granted.
Exactly.
Together with an NIE.
That's exactly the distinction. If you're granted the E2s now, which of course they're all on pause in terms of appointment, but if you were granted one recently during COVID, when NIE was in effect, then you would get the NIE. But in this case, the answer is they can reapply for the NIE. They might, I'm happy to look at what they presented already, because you have to make sure that you're meeting the standard that exists today. So if they applied during the time where it was just critical infrastructure and not business necessity, there was a high chance they were going to get denied. Business necessity, economic necessity is the perfect argument to make now again for NIEs if you have an E2, because you're protecting your investment and creating jobs.
Exactly. This could have been denied in that period from March to June.
Yes.
It may actually be more successful if you reapply now.
Yeah, so I think that thinking that E2 is automatic maybe is what triggered people to just submit very light petitions. And I think you have to present it very strongly and get the backing of any US-based companies that are also involved in what you're going to be doing. And then you should be successful now.
Okay. Now, can you elaborate a little bit more on forum shopping? Because not everyone understood that.
Okay, so forum shopping, what that means is that like I mentioned, every embassy and consulate has their own rules and regulations. So there are certain embassies like the one in London where you have to be a resident of the UK in order to get a visa. But there are certain countries like now Switzerland where the US embassy was allowing and now is allowing again non-residents to apply. So forum shopping means that you can get appointments in different embassies and consulates for the same visa that you want to apply for. And if they're willing to actually give you the interview, and then you can get your visa there. So that means shopping around means getting various appointments. I did one for a Brazilian client who had appointments at 3 of the consulates in Brazil, and one of them took her right away, and she was able to go to the US and get her visa to study. Otherwise, she had appointments in November and December at the other one. So it's a question of researching where they stand and then applying, and you have to pay that DS-160 fee for each one, and you're going to lose those funds, but you have a chance of getting your visa faster if you find the right fit.
Great. There are many more questions at the moment that we can probably answer within this session. So I encourage people to ask questions, and we'll what I think we should do is then try to answer them in writing when we follow up with everyone. But I'm going to try to address a couple of them that jump out. Family emergencies in the Netherlands. I think we talked about it briefly, but so that is currently in the US. There's a family emergency, death or a sickness in the Netherlands. What would your advice be?
Well, I think that family does come first, and this is Murphy's Law. It happens all the time. If it's an absolute emergency, then you don't want to regret it later, having not been there when your grandma passed away or whatever it might be. So obviously you want to travel, and I would say consult with someone to plan your strategy before you leave, or as soon as you've left, in terms of how to get back the safest way or the quickest way back into the United States, depending on your situation. So yes, absolutely. If it's an emergency and you have to be there, then you have to be there.
Yeah. And you mentioned that there is a delay at the moment for the regular visa applications, the E's, the L's, of 4 to 6 months. Now that's the delay is 4 to 6 months, or is that the total processing time at this point?
That's just the delays. So if you get in the queue now for E2s, I think that you're adding the typical 10 to 12 weeks of processing once they actually activate your case. So it depends on the visa category, but I would say for ease, it's longer. And for other ones, you're looking at 4 to 6 months, and that's shifting. So the most important thing, like I mentioned before, is making sure you have an appointment, but moving back the start date. If you've got any of those petitions like L's or O's that you're presenting in the United States, push the start date back to, let's say, the end of the year or beginning of next year, so you don't lose time on your visa on the back end.
Very good. I think we've covered a lot of them. Let me see what I can pick out. Work for a Dutch company and here in the US on a green card. This Dutch company has US entity and soon people from the Netherlands headquarters have to visit. Is that considered urgent? If they would they qualify for an NIE?
I think so. I think under the economic necessity argument they would, but I'm assuming they have visas in place.
From what I read, they don't have visas in place. They would basically, the management of the Netherlands would be traveling to the US.
Okay.
From what I've seen myself, one of the trigger points there is that as long as you show that it's necessary in order to keep the company alive or to make it grow and employ more people. So if there's an employment aspect, that really seems to work well. Do you agree?
I think you're right, but it also has to do with making sure that you're not crossing the line in terms of what's allowed. So as long as you're representing the foreign entity and you're keeping in line with what's allowed under ESTA or a B1 visa, for example, as a business visitor, then you're fine. So you have to be very careful in terms of the language that you use to explain what you're going to be doing, because you can't be assuming a role that you're not allowed to, right? So there's a very fine line there, but yes, it's possible, but you have to be very careful how you present it.
Yeah, and I know it's kind of a trick question, but can you explain a little bit more on when you're allowed to represent the Dutch headquarters or as a president of the US Inc., what are you actually allowed then to do? And what should you really not be doing?
Yeah, this is the question that we've been getting for years together, right, Jacob? And I could talk about it for a lot longer, but essentially, you have to just do things in the US that are set up activities. And that includes negotiating contracts, negotiating a physical space, incorporating, doing business meetings, but nothing that generates revenue for the US company. So it has to be restricted to setup. Once everything is set up and in functioning, that's when you need the visa to actually be doing the things for the US company that you're not allowed to do otherwise. So it's all set up. That's how I would think about it mentally. Anything that's a setup activity, but once the company is ready to operate, you can't be moving forward and representing the US entity. So the safest thing to do is always to say you're representing the foreign entity and you're doing the setup of US operations. If you keep that language in your description, I think that should be sufficient.
And that's also important to explain at the border to the officer.
Absolutely, for NIEs, but also be ready to say the same thing when you get to that, when you get to the immigration post and you need to explain the purpose of your visit.
Yeah.
Having the NIE approved with the same letter and everything, taking that presentation with you is also very helpful in that respect.
Very good. Yeah, because that's the thing. I saw a couple of NIE applications that basically admitted that they were going to do things in the US that they were under the visa rules not allowed to do, the work permit rules. So in your visa application, make sure that you don't say that you're going to be doing things in the US that would get you in trouble with your work permit.
Yeah, and you know what? The immigration system has separate divisions, and Department of State is separate from Homeland Security, but they do share information. And so that possibly could lead to your company being blacklisted. I had a company in the UK that didn't take my advice and they got blacklisted for 3 years. They can't sponsor anyone. So you need to be very careful when you're representing the US company, what you're saying as an individual, because it also has repercussions, not just for you, but for the company.
Excellent. Like I said, there are many more questions, which is a good sign. But we need to wrap up here. Steve is available to address more questions in writing, so we'll try to jointly work on kind of categorizing the remaining questions and try to answer them. But he's also available for a 15-minute free consultation. So the last slide on his presentation has his contact info. Willemijn, I think you wanted to also explain still the upcoming events for
Yes.
the NAF.
Absolutely. Thank you so much, Jacob, and thank you so much, Steve, for this incredibly important webinar. We really are very, very lucky to have had you with us for this past hour. The next webinar that NAF Biz will be organizing will be on September 9th, and it will be featuring Roel Houning, who is the president and CEO of John F. Kennedy International Air Terminal, and he will be speaking about the expansion of the terminal and what it means for the Dutch American business community and the business community at large. So I hope to see everyone there. Thank you so much, everyone.
Thank you so much, Willemijn. Leaves me to thank Steve a lot. He's been a great resource for NAF members. I hope you found this webinar as useful as I found it. I learned a lot of new things myself. So thanks so much, Steve, for sharing your knowledge with us. And I encourage everyone also to make sure that you keep in touch with the NAF through the LinkedIn pages, where we try to share also updates. If there are any updates about changes of the NIE or travel restrictions, we'll try to share that with you through the social media. With that, thanks so much for attending, and I look forward to seeing you in a future webinar, or if possible, live. Thanks.
Thank you.